Welcome to the fourth presentation on Chapter 2, the chapter entitled The Inner Workings of a Law Firm. We are up to filing procedures, so I'm going to go forward to that section. Files obviously have a huge importance in a law firm, probably more importance in the law firm environment than in other types of office environments, because the information that are in the files is really the final product that is being produced by the law firm. If we were a factory that made widgets, we'd certainly have files about widgets, but at the end of the day, we'd have to be putting our widgets in boxes and we'd be sending that out to our vendors to sell, and that is the most important thing that is being produced in the factory where we work. But for a law firm, we don't produce widgets, we produce words, we produce ideas, we develop research, and all of that are things that go in files and that can be filed. So that's an important part of the reason why files are so important. But there's a second reason, and that is clients tell their attorneys and paralegals their secrets, and the clients are entitled to these secrets being held in a very confidential way. So while our files are important, they're also very important they be handled in a very careful, confidential manner. So for those two reasons, the maintenance of files is a fairly big issue at a law firm. And it's one when you walk in, you ought to be aware that this is a major source of concern for law firms. Files are not to be treated in a casual way. Why do law firms have files? Well, one is to retrieve information promptly. You're billing your time. If you have to spend an hour to find a file, well, somebody's going to have to pay for that hour, and people aren't going to really want to pay, $100 or $200 for you to locate a file that should have been immediately available to you. And then secondly, you need to have procedures in place that are going to protect the confidentiality of the file. Now, these two concerns are in tension with each other. If you had a system in which files were immediately available to everyone, it might be easier to actually get the information, to have the files more readily available. That might make the speed in which the files were acquired quicker. If you made the files readily available, though, you might find that some of the confidentiality protections would be undermined. So law firms have to be concerned about both of these concerns. Imagine, for example, that you have a client. I'll go back to the example. Let's say your client is Deion Sanders, and you're at a large law firm. And you might imagine that there might be people who work, maybe other attorneys, maybe paralegals, maybe support staff, who would be interested to know more of the specifics of Mr. Sanders' divorce. So under those circumstances, you might say, well, you know what, we can't maintain Mr. Sanders' file in the main file room. That would be more convenient. That would make everything prompter to handle, but we would be undermining the confidentiality. Well, in a tie, confidentiality is always going to take precedence over promptness. Usually there doesn't have to be a big trade-off between the two, but certainly there can be some tension between these two concepts. It is so important that you never share client information outside the firm, or you never leave it unattended in a publicly accessible location. It's so easy when you're in the courtroom, for example, to accidentally leave a file behind, or perhaps you have some documents on your smartphone or your laptop and you leave that unprotected. Even doing something like working on a plane, where you have somebody sitting next to you who can see what you're typing, that is a breach of attorney-client confidentiality. So it's very important this information is very protected. We're going to talk more about this topic in Chapter 3, but I just want to flag it for you. In your standard business situation, it's probably not hugely important that people don't overhear conversations, or at least the vast majority of them, but in the legal environment it is very, very important. You need to take a lot of precautions in that area. Being too casual in this area is certainly going to cause you not to be held in the same esteem that somebody who's more careful is going to be treated. Let's talk about how law firms typically do this. And of course, law firms have different filing systems. Part of the factors that cause law firms to have different filing systems is what is the level of technology. Nowadays, many files are maintained electronically instead of in a paper format, or a law firm might have paper files and electronic files. So part of it depends upon the technology level of the firm, and of course that's a function of how large the firm is, what kind of resources the firm has, perhaps even the age of the people that are making decisions. If you have people who grew up in an age of paper files, they may be more comfortable with them and they may be less eager to make the change. Another factor that affects how files are set up is what the nature of the practice is. There are certain types of practices in which files are very, very large, other practices where the files might be relatively thin. So you have to consider that when you're looking at things. When I was in private practice, I worked on 2 death row cases, 2 habeas appeals. And one of those I worked on more than the other, and I viewed the district attorney's file for the prosecution of my client. And the whole file fit into one banker's box. That was the whole size of the file. And yet I can tell you my civil litigation, I don't think I've ever had a case that didn't involve several banker's boxes size of data. Now, you'd figure a death row case would be more, it would have more stuff associated with it because of the severity of the possible penalty. And yet it actually had a very, very small file, very thin file. So part of it turns upon the type of practice that you have, as well as the level of technology that you find in that particular law firm, and then the number of files that have to be maintained, and how is that function staffed. Some law firms will have a file manager who will actually retrieve the files, and the attorneys and the paralegals won't even be permitted back, at least during the day, because of the concern that they might misfile a document or put something in the wrong place. Other circumstances where the departments are smaller, that might be a situation where lots of people are back in the files, and there is that possibility of things being misfiled. So the takeaway I want to say is that you can't go into a law firm and know before your first day exactly how things will be maintained. But I'm going to give you some general rules, some kind of rules of the road about how files are often maintained in this type of environment. Typically, a file is going to receive a unique file number, and this oftentimes will be an alphanumeric number. Many times the beginning of it will be maybe the initials. Let's say Mr. Brown is our client, so I might do his first 3 initials of his last name, and let's say his first name is James, so I might do the first initials of his last name. So that might tell us our unique designation for our particular client. And then there might be a numeric number to indicate what matter this is. Let's say we've helped him with his will, so that was BROGA001. And then we helped him form his small business entity, and that was BROJA002. And then he sued his plumber when he had his pipes leak, and that became BROJA003. And this is a fairly simple filing system, there might be additional information to describe the matter. For example, the first one was a will, so this first number might have been a W. And then when we were doing the establishing a corporation, this might have been a C. And when we were involved in litigation, we might have had an L here. So there's a lot of data sometimes that exists in the file numbers. Typically, within a file, there's going to be subfiles. Files are ordinarily arranged in what are called, or commonly called, red wells. They are accordion-style files that will actually sit up, and they're usually kind of a rust color. They will be able to stand on their own, and then inside you'll put slender manila folders in here. And so each one of these manila folders would be a subfolder. They would include certain information. I'll give you an example from a litigation case. You might have, that would be an example. You might have a correspondence file. You might have a billing file. You might have attorney's notes file. There might be several of these files where just the musings and comments of the attorney or the paralegal, for that matter. There would be court papers file. There would be discovery files. There might be an extras file where you have duplicate copies of a particular document that go in that. You might have drafts of documents that you might maintain in that file. So you can imagine, and of course some of these, for example, the deposition files, they might actually end up being several boxes size of data in those. Something like the correspondence file will probably be able to fit all within 1 or maybe 2 manila folders. So different subfiles within that. And of course, each one of these manila folders will need to be labeled so that if it gets out of this larger Redwell folder, someone will know how to get it back into place. And typically the papers in each one of these files won't be loose within the folder. They will actually be attached to the folder. Imagine, for example, that this is our manila folder. Here we go. So this is, there would be like little brackets up here, and so you'd put a page, you'd two-hole punch the page up here, and you'd put one page, and then another page on top of that, and another page on top of that. And then when you're done, you put the little brackets down so the pages wouldn't be able to fall out. That helps ensure that pages aren't inadvertently lost or mislaid. Typically, the documents are going to stay in the file. If you happen to need the third page in this stack, you're not going to take it out and go about your business with it. What you're going to do is you're going to take that whole manila folder to the copy room, remove the page that you need, photocopy it, and then return it immediately to the copy. That way, there's less of a risk of it becoming damaged or separated. Nowadays, many times documents are scanned in so you can have an electronic file as well as a paper file, which makes a lot of sense. If you have the electronic file, everything's scanned in, then if you happen to lose a piece of paper, it's much less serious matter. Once the matter is concluded, then it's typically going to be closed. Sometimes it may not be 100% clear whether a matter is concluded or not. For example, let's look at this litigation. Let's say your client won $100,000, but you discover, so you think, well, the case is going to be closed now, but you find out that the other guy is going to appeal the matter. Well, then the matter isn't closed after all. So sometimes there can be some fluidity. Sometimes you're not quite sure what the status is, but ultimately there's going to be some conclusion. You may have to keep a file kind of in limbo for a while. Once the matter concludes, though, you don't shred the file. Typically, you're going to send it to some kind of off-site storage for some period of time, typically for years before you actually shred it. There are several reasons why you want to maintain the file for a significant period of time after it's been closed. One reason is that you may find certain parts of that file can be useful for another case. Let's say you did some research regarding the statutory period for a particular claim. Well, you might encounter a similar circumstance later on, so it would be helpful to have a file, at least that information in an electronic file, some kind of searchable format so that you don't have to reinvent the wheel when a similar matter comes up in the future. Another reason that you might have it is, again, for your professional development, for performance evaluation time, or when you are getting your portfolio together to apply for new positions. But probably the central reason why the file is not immediately shredded is the third, and that is that there's a statutory period that applies to your claim. Let's say your client is delighted with the results. He's gotten $100,000. He's happy. He's saying, oh, you did a great job. Well, that's how he feels now. But one thing about clients, and this is kind of true of life generally, is that you can't assume that good feelings are going to continue forever. It may be that your client in 6 months starts talking to a buddy and says, hey, I had this great result when I sued. He goes, wow, you should have gotten a lot more than that. That attorney didn't give you good advice. And then your client who thought you were brilliant is now thinking about it. Well, maybe I didn't get everything I should have. Maybe my attorney didn't help me to the extent that I feel like he ought to have helped me. And lo and behold, 6 months later, he's suing you about the matter. Attorneys and paralegals always work under the assumption that this loving, wonderful relationship is not necessarily going to last. And so you always hope for the best and plan for the worst. You always are preparing, well, if this doesn't go well, I want to make sure that my file is in order to support the recommendations that I made and the decisions that I made in the matter. So that's one of the reasons, and we'll talk about this in Chapter 2, one of the reasons that you document the file. Of course, if you turn around and shred it right after the lawsuit's concluded and you end up getting a malpractice claim, well, you won't have your documentation to show the decisions that you made and why you made them. As a result, you're going to look for the statutory period for a malpractice claim in your jurisdiction, and you're going to maintain that file until that date. And only then are you going to shred the documents in the file. And if this is a long-standing client in which you have several different matters going forward, it might even motivate you to maintain the file for a longer period of time. The takeaway is that legal professionals are pack rats. We keep documents probably for longer than we need to because we always live in fear of throwing away the one thing that we're going to ultimately need to know. So the destruction is going to be delayed until the statutory period is expired. Work product files and references. As I said before, you're going to want to take out your legal research that you prepared in that case because you may be able to use it in a subsequent matter. You'll also want to use any legal forms, and many times it's going to be held in an electronic file. It's relatively rare for a legal professional to start a legal writing project from scratch. He or she is almost certainly going to have some model to work from. If it's an area of practice that he or she ordinarily engages in, then the legal professional will likely have a form that he or she has used in the past. And, of course, he's going to have to cut and paste and remove and add and maybe combine documents and things like that. But if it's a situation where he's never practiced this area before, he or she may well use a forms product, a forms file, something either that he borrows from someone else or that he gets from some kind of publication. Certainly there are legal professionals who start documents from scratch, but usually it's a little bit like reinventing the wheel. Why start? Why invent something when there's lots of models out there to use? And so if you've developed a document in a particular folder that you think, hey, this is going to be useful when I encounter facts similar to this, you're going to want to save that in a location and in a format that's going to make it accessible to you when you next need it. Let's talk about financial procedures. We think about the practice of law as a profession, and it certainly is a profession, but it's also a business. And certainly lawyers and paralegals are involved in the practice for lots of reasons, but financial reasons are a big part of it. So let's talk a little bit about this. And again, these are topics that we'll talk about in more detail when we are talking about legal ethics. But one of the requirements for fees are that they be reasonable. We'll talk about the word reasonable a lot throughout the paralegal program, but let me flag this. And whenever you see the word reasonable, automatically think objective. This is an objective standard. Everybody, or most everybody, thinks of himself or herself as reasonable. Not too many people say, yeah, I'm unreasonable, and I know it. They think they're reasonable. The rest of the world may think they're not reasonable. You may recall, some of y'all might recall, several decades ago, there was the wife of President Marcos of the Philippines. Her name was Imelda Marcos, and she had over 3,000 pairs of shoes. Now, I'm sure she thought that was a perfectly reasonable thing, but she became famous for this shoe obsession that she had. And most people would have said, well, that was a ridiculous amount of money to spend, especially when you're the leader of a country where many of the people have very, very difficult economic circumstances. So it seemed very unreasonable to have that type of luxury. But people, and I'm sure Mrs. Marcos included, thought this perfectly reasonable. I'm sure she had to entertain people in her job. Maybe some of these shoes were made by Filipinos, and so perhaps she was marketing the excellent quality craftsmanship of her countrymen by wearing these shoes. Who knows what her justification is? I'm sure it was reasonable to her, but it was not objectively reasonable. So when we look at things like reasonable fees, we're looking at what would somebody, maybe a fly on the wall who isn't economically involved in the transaction, would that fly, look at the situation and say, yeah, that's a reasonable fee under the circumstances? Now, of course, clients typically take the opposite view. They think all fees are unreasonable, right? It seems, when you think about it, there's an attorney in the Dallas-Fort Worth area, a very well-regarded attorney, who charges $1,000 an hour. But I think many of us would think, wow, nobody is worth $1,000 an hour. That's over $100 a minute. That seems beyond a reasonable fee structure to have. And that may or may not be reasonable, but he would make an argument that it is reasonable because he has a lot of experience, has had tremendous success for many of his clients. He has he's a very well-known legal professional in the industry. So he'd say, and he practices in a large metropolitan area, the Dallas-Fort Worth area. So those factors, he would say that even though it sounds like a lot of money, it is objectively reasonable. However, it would be objectively unreasonable for somebody who's just graduated from law school to charge $1,000 an hour, or for somebody who hasn't made a name for himself or herself in a particular field to charge that amount of money, or somebody in a small town to charge that sum of money, or for a paralegal to charge that amount of money. Even though that paralegal may be the best paralegal out there, it's not objectively reasonable. Would that fly on the wall think that's reasonable? So that's the first thing that we have to think about when we're thinking about fee arrangements. Another thing that is commonly done, and this happens more often when your client is an individual or a small corporation, is that the law firm may request a retainer agreement. They'll request a retainer agreement, but we'll talk about retainers in a second. But a retainer agreement or a services agreement is going to describe the scope of legal services and the payment fee structure. Many times it will involve a retainer. But what this agreement does is it retains the services of the law firm. Now imagine that my particular practice area, I'm the attorney, and I do wills. That's my job. And I have somebody come in to see me, and he says, I want to make a new will. I say, okay, I'd be delighted to provide you services. And I present him with a retainer agreement. He reviews it, and he signs it, and we've established a fee structure, and I'm going to handle his will. Then a month later, he comes back, and maybe we're finalizing the will, and he says to me, oh, by the way, I need a prenuptial agreement. I'm getting married. I say, well, I don't do that kind of work. I can refer you to an attorney who can assist you in that matter. And he goes, well, you're my attorney. We sign that agreement. And then I can point him to the agreement and say, look, I'm your attorney for wills. I'm not your attorney for other matters. And so I have narrowed the source of my representation, because the reality is, even though an attorney who's admitted to practice in Texas is admitted to practice in front of any court in the state of Texas, but still, there is a lot of specialization. I may feel I may not be interested in doing prenuptial agreements, or I may feel that I am not sufficiently qualified to handle that type of matter. So under those circumstances, I'm well within my right to say, nope, don't do that kind of work. And a carefully worded retainer agreement can, many times, work to soften the feelings, maybe make that client feel less offended if you aren't able to provide services. There are three fairly common fee structures that you'll find in fee arrangements between attorneys and clients. Let's talk about the two less common ones, and then we'll end with the most common one. Let's talk about fixed fees. This is the least common. Imagine for a second that you are wanting your will written up. You need some assistance with that, and you go to see an attorney. The attorney says to you, I bill $200 an hour. Do you want to hire me? Well, your first thought is going to be, well, that doesn't really tell me what I need to know. Does it take you an hour to make my will? If it only takes you an hour and so the whole bill is going to be $200, yeah, that sounds reasonable. But if it's going to take you 40 hours to write my will, then that's going to be $8,000. And I don't have anything fancy in my will. I'm not a wealthy person. So that seems too expensive. So an hourly fee structure really doesn't tell me what the bottom line is. How much am I actually going to have to pay the attorney when everything is done? That's why fixed fees are very popular, especially when you are dealing with individuals. They don't really care how many hours it takes. What they care about is, what is my bill going to look like at the end? So for simple, predictable matters such as uncontested divorce with no children, or traffic tickets where the person is planning on pleading guilty, or a simple will where there's assets, say, under $1 million. Pretty straightforward matters along those are the establishment of a simple professional corporation or a simple LLC or something along those lines. The attorney practicing in the area has a pretty good idea. Hey, it takes me between 7 and 10 hours to do this, or it takes me from 30 to 35 hours to do this. And so he establishes a fee structure where he looks at what his hourly rate would be, does the math, and comes up with a number. And then the client would pay that number. And if the attorney can actually produce the work in less time than he had hoped, well, then the attorney is kind of making a bit more profit. On the other hand, if the attorney hits some roadblocks that ends up taking him more time than he expected, then the client's getting a deal. So in that situation, you're giving some certainty to the client, but you're also, the attorney is giving up the possibility of some additional fees, but the hope is that he's going to attract more business by having fixed fees. The challenge with fixed fees are that there's always that kind of Murphy's Law idea that things always end up being more complicated than you'd ever think they would be. And so many times people who've worked with fixed fees will say, yeah, I thought it would only be 7 to 10 hours, but it ended up taking 25 hours, and I didn't make any money off of it. And so they become hesitant to do it in the future, or they really limit it to very, very simple matters that it's very easy to predict. But that's a fixed fee arrangement. You can see how that's useful when you're dealing with clients who aren't especially wealthy. The next are, let's talk about hourly fees. I know I said I was going to save hourly fees for last because this is the most common arrangement, but this is very intuitive. Imagine that I hire an attorney and he says to me, I bill at $200 an hour. That means that every time he does work for me, and let's say he spends 5 hours working for me, I'm going to owe him $1,000. In addition to the $1,000 that I will owe him, he may also have expenses. For example, maybe the secretary made 100 photocopies, and maybe the law firm charges 25 cents per photocopy. So in addition to that, now I also owe him $25. So my bill would be $1,025. There might be some taxes and other fees associated with it, but that gives you a ballpark sense of what the bill would be. This is what attorneys like to do. This is their go-to position because it moves them out of the business of predicting how many hours it would take. Now, I've talked about how attorneys aren't always the best managers. They're not always the best predictors. There's so many different variables that go right. Is the opposing counsel going to be unreasonable? Is the client going to be unreasonable? Are there going to be surprise facts or complications that make this project more time-consuming? So the hourly fees really removes the need to predict and anticipate to the same extent. But, of course, you can see how the client doesn't really know, is this going to be 5 hours or 20 hours or whatever. So you can see why clients sometimes don't care for this arrangement. Another reason that clients don't like this arrangement is that it encourages attorneys to spend more time on a matter than is perhaps strictly required. Maybe I can do a Hyundai level job for the client for 10 hours, so it costs $2,000. But I'm thinking to myself, I've got some extra time. I'm not too swamped with work. Instead of just spending 10 hours, why don't I give him the Cadillac or the Lexus version of the job? I'll spend 20 hours, and I'm really going to research every case and really work very hard at writing the most lyrical prose I can do and just really do a thorough job. Well, the client maybe wants the Cadillac version, but maybe he also wants the Hyundai version. Maybe he would have been happy with paying $2,000 for the Hyundai version instead of paying $4,000 for the Cadillac. And so you can see that the temptation with hourly fee is that the attorney will overwork the file. Now, all of these fee arrangements we'll see, as we talked about the dangers associated with the fixed fee situation. The hourly fee situation has this potential for the client's interest and the attorney's interest not to be perfectly aligned. The attorney, for example, has an incentive not to settle the case, because as soon as it settles, guess what? He is no longer going to be able to bill to that matter. So he has an incentive to work the file a lot. Maybe after he's worked it a lot, say, hey, maybe we should settle it. Now that I've gotten a lot of money in legal fees, now it's time to settle the case. So you can see how the interests are not perfectly aligned. But you know what? We live in the real world. There is no fee structure that perfectly aligns the interests of the client with the attorney. We live in the real world, and so an attorney and a paralegal have to be very aware of this. They should not put their economic interests ahead of the client's interests, because you're a fiduciary as a client. So you ought to be thinking not, how can I maximize my billable hours and maximize the profitability of my law firm, but you ought to be thinking, what would I want my attorney to do if I were that client? So that is how hourly fees work. And this is, again, the most common structure to have. Now let's look at contingency fees. This is used by plaintiffs attorneys. Imagine that I'm in a car accident. I'm sitting at a red light, someone rear-ends me, and my car is totaled. I have significant injuries. I have medical bills that are significant. I'm not able to work. I'm in a pickle. I don't have income coming in. I've got a lot of bills. I don't have a means of transportation. I am in a very significant financial problem. And let's say that the law firm of the person who rear-ended me isn't being reasonable in terms of settlement, so I don't accept that offer. So I'm going around trying to find an attorney to accept my case. If I go in to see an attorney and he says, well, yeah, I'm happy to take your case. My hourly rate is $200 an hour, and you'll have to pay me every month when the bill comes due. Well, gosh, I don't have enough money to pay my bills as is. I certainly don't have the ability to add more money to my tab. And a case might not go to trial in a state court, especially for a year or two, maybe even 3 years. And if it gets appealed, you could add several more years on top of that. So under those circumstances, if I had the money to pay those fees, I probably wouldn't be suing in the first place. Contingency fee setups are designed to address this issue because many times plaintiffs are not in a position financially to pay those types of fees. So what happens when an attorney agrees to represent a plaintiff on the basis of a contingency fee is the attorney says, I'm going to buy a part of the lawsuit. So maybe the plaintiff is going to accept, we'll say 70% of the proceeds. and the attorney is going to own the other 30%. So let's say that the jury awards the plaintiff $100,000. That means that the plaintiff is going to get $70,000 and the attorney is going to keep the $30,000. This would work the same way if it's not the jury who decides that the amount is going to be $100,000, but maybe it's a settlement proposal that gets accepted. Now you can see in this situation, if the plaintiff's attorney is able to persuade the defense attorney to settle the case for $100,000 the day after the lawsuit is filed, then that attorney gets $30,000 for his law firm with almost no work, maybe 10 hours or less of work. That's a pretty high hourly rate there, right? But if he were to take the case to trial and spend thousands of hours, he'd still get exactly the same number, $30,000. So there is no change to the amount that the attorney receives based upon the number of hours. Let's imagine in the scenario, let's say that we use the same percentage, 70 and 30. In this situation, the jury doesn't believe your client's story and awards him nothing. Well, 70% of nothing is nothing. 30% of nothing is nothing. So the attorney who has spent hundreds, thousands of hours preparing for this case ends up with nothing. And so you can see how the attorney is only going to accept contingency fee cases that he feels he can win. That he's typically looking for three things. He's looking for a situation where the plaintiff has a strong factual claim. For example, the example I gave of being rear-ended at a red light. Well, it's hard not to find liability under those circumstances. If the plaintiff had been drinking or been driving at excessive speed or something like that, the attorney might be less likely to accept the case on a contingency fee basis than it would in a case where there's clear liability on the part of the defendant. Another thing that the plaintiff's attorney is going to look at before accepting contingency fee is see the level of damages. Even if there's clear liability on the part of the defense, if the damages are small, for example, it's just a case of a fender bender, there were no significant medicals, it was just structural damage to the car, maybe $3,000 to $4,000. Well, even if you get 30% of $3,000 or $4,000, that's not a lot of money. If you were at the case for just a day or two, you need to, you've already gotten to the point where you're going to be losing money on the case. So you need to have significant damages. And then the third thing is you need to have a defendant who has some level of a deep pocket. So let's say that there's clear liability, clearly the plaintiff was in the right, the defendant was in the wrong, and had significant injuries. But it's an automobile case, and the defendant was uninsured or underinsured. Under those circumstances, you can't get blood out of the turnip. If the defendant doesn't have money and doesn't have insurance that's going to pick up the tab, it doesn't matter how strong the case is, the plaintiff's attorney isn't going to be interested in taking it. So those are the three things that the plaintiff is going to want to be able to prove to the attorney if the contingency fee is being considered. The textbook talks about the initial interview wherein the client and the attorney are meeting together to decide whether there's a basis for representation, whether this is going to be mutually advantageous. The textbook talks about the attorney really being the one conducting this presentation or this meeting between the client. And it certainly happens that the attorney is present oftentimes, especially when it's a fixed fee situation or it's an hourly fee situation. When it's a contingency situation, though, it's not unusual to have a paralegal be the only one conducting this initial interview. Many times this is called an intake position. And if you have joined our Collin College Paralegal Association group, the LinkedIn group, you will soon see that intake paralegal positions are a fairly common one that you will see posted. And it is oftentimes kind of an entry-level paralegal position. And what a paralegal in this position will do in a plaintiff's law firm is meet with potential clients, potential plaintiffs. And what the paralegal will likely have is a checklist of questions to ask, and the paralegal will take notes and interview and get the information. And then through some kind of decision-making matrix, we'll make a recommendation to the law firm, hey, this is a case we ought to take, or this is a case we ought not take. For example, let's say that I am the client or the potential client, and I come in saying, oh, yeah, I was rear-ended at the light, and here's all my medicals. Well, the paralegal is going to look at it. Do I really have significant medicals? Does the police report match what I'm saying happened? Do I have strong facts? What is the scope of the insurance that the defendant has? And so check those things to see. And if all of those things are present, then the intake paralegal might well recommend to the law firm to consider taking this case. At the end of the day, it's not the paralegal, though, that can make that decision. To establish an attorney-client relationship, you need an attorney and you need a client. Having said that, though, the attorney in that type of environment will likely give a great deal of deference to the recommendation that the paralegal has made. So that is a common position in a law firm that handles contingency fee situations. You'll find in those environments that the majority of potential clients who come in are going to be turned away. They aren't going to have either the evidence that they need to win the case or the amount of damages or the deep pockets. The person either has assets, a significant amount, or has insurance. And so this is a screening process that the paralegal would assist in. Oh, let me go back here. I was talking before about how hourly fees, there is a tendency for the law firm to overwork overwork the file. Well, in contingency fee situation, the temptation is the opposite. And this is similar to the fixed fee situation. The tendency is to underwork the file. Think about it. If you know that, if you spend 1,000 more hours on the case, but you think the most that you're going to generate is maybe $10,000 more in damages, or being able to prove damages, and you're only going to be able to keep 30% of that, so the amount of money that the law firm is going to take is $3,000. Well, it's not a very good investment for you to spend $1,000 to generate $3,000 worth of income for the firm. That's only $3 an hour. But you can imagine the client could say, well, I don't care how many hours you work. If you can increase my damages to $10,000, which means I would take $7,000, you ought to do it. Because after all, it doesn't hurt me that you have to work more. I want to get that extra $7,000. So you can see how there's a tension between the expectation of the client and the expectations of the law firm. So under those situations, there might be the tendency in a fixed fee or contingency fee arrangement for the attorney or the paralegal to underwork the file. Again, that tension is real world. That's what happens. The interests of the client and the attorney are never perfectly aligned, but the attorney always ought to be making reasonable judgments balancing those interests. Let's talk about IOLTA accounts. IOLTA stands for Interest on Lawyer's Trust Account. Let me write this up here so you can see it. Interest on Lawyer's Trust Account. This exists in all 50 states, including Texas. So this will be something that you'll see wherever your practice is. And it's called IOLTA accounts, as far as I know, in every state. When a client trusts you with his money, that can arise in several situations. There can be the retainer situation, wherein the client is saying, hey, hold on to this money for me. I know that I'm going to be needing your services. I want to prepay my legal bills. And that can be a way that the attorney can be confident that the bill is actually going to be paid. So that is one situation where a retainer is provided, where the client is entrusting the money to the law firm. Now, if I give my attorney, say, $5,000 for this retainer, and it ends up that we settle the matter the next day, and the attorney has only spent $200 the retainer. Well, the $4,800 that remain in the account, the attorney has to promptly refund to me. It's not his money. The only part of the money that's his is the amount that he's actually consumed through the amount of work that he's done. The money remains mine even though he's holding on to it. So the retainer situation is a common reason that a lawyer might be handling the client's money. Another situation might be that the client may have received a settlement or may have received a judgment, and so it may pass into the attorney's hands for some brief period of time until it can be dispersed to the client. That would be another circumstance. And there's some others too, but those are two common ones. When the attorney has the client's money, the attorney can't just put it into his ordinary bank account. You know, the account that he uses to pay rent on his office space, or that he pays wages for his employees, or the account that he uses to buy paper or pencils or things like that. It has to be separate from the firm's funds, and it needs to be held in an IOLTA account. There has to be careful tracking of the deposits to the account and the withdrawals from the account to make sure that there is money being accounted for in a very careful way. Probably commingling of funds, not keeping the funds separate, or not the careful accounting is one of the most common things that can happen to an attorney that can cause him to get into trouble with the Bar Association and possibly be sanctioned in some sense, possibly even disbarred. So this is a major source of concern for attorneys to make sure that these accounts are maintained in a careful way. And oftentimes, particularly in a smaller firm, will fall to the paralegal to maintain the bookkeeping associated with this. Let's talk about billing and time-consuming procedures. You know, we'll go back to the example of the widget factory. The widget factory produces widgets, so they're going to keep track of how many widgets they make and how many hours it takes them to make their widgets and all that stuff. Well, it's even more important in a law firm because the passage of time is the product that is being sold. So you need to have very careful timekeeping procedures. When I began my practice over 20 years ago, attorneys and paralegals kept books, which diaries, which they were called, or journals, I think is what they were called, where you maintained your time records and you wrote it out in longhand. You wrote out what, the client account number, the amount of time spent, and the tasks that you did, and then the secretary would input it into the timekeeping software, and it would spit out a bill that would be presented to the client. Nowadays, of course, these are typically entered electronically by the actual person who is keeping time, so there isn't that intermediary. Generally, though, the expectations of the client can vary. I'll be honest with you, when I was in practice, I worked for a client that wanted very detailed bills. And if a law firm that we were hiring did not provide very detailed records, we would return the bills to them and tell them they need to provide more details. If they weren't willing to do that or able to do that, then they weren't going to get very much business from us. And that's a fairly common reaction that corporations have, larger corporations especially. If it's a smaller corporation or individual, they may be less picky about the way their bills look. They may be more focused on how much they're actually paying versus how the bill actually looks. During a day, my experience was in order to bill 8 hours in a day, I usually had to work about 10 hours, and that's excluding lunch and time that I'm not directly working. If I'm in the ladies' room or if I'm talking with my friends, I'm not including that time. The reason is that you need to spend about 2 hours doing work-related things that you couldn't bill to a particular client. You might be in a staff meeting. Just the time you took to record your time might easily take 30 minutes in a given day. You might need to do some filing that you can't charge a particular client. You might have done some continuing legal education or kept abreast of some legal developments. That's not going to be billable to a particular client. So I found that it took about 10 hours of steady work to be able to bill 8 hours. Now, there were days where I worked 8 hours and I billed 8 hours. There were also days where I worked 10 hours and didn't bill a single minute of that time to any particular client. So there's a large continuum. Part of it depends upon your particular practice and how busy you are and what's going on. But it certainly isn't the case that that if you're at work 8 hours, that you're going to be able to bill 8 hours to a client on a particular day. The client is generally billed for time spent and expenses incurred on the client's behalf. The client benefits from all that continuing legal education that you have, but the client isn't going to pay for that unless it is you only are going through this continuing legal education to prepare for this client's work. Here's an example of a bill. I hate this bill. This is from the textbook, so I'm including it here, but I'm mainly including it as a cautionary tale. This provides almost no information. Initial client consultation. Well, I can see that would be okay because the client was obviously present for the meeting, so you don't really have to spend a lot of time telling him what happened since he was already there. And I even see the next one, client interview. Okay, he was there. He was being interviewed. He knows what was being discussed. Um, but the next one, document preparation. What document was being prepared? Um, was research required? I would definitely want more information about that. Interview of Suzanne Matthews, nurse. I'd want more information about that. What was the topic of the interview? Maybe it's obvious under the circumstances, but again, I would usually find not so much for an hour spent, but if we're talking 2 or 3 hours, I would want 3 or 4 lines at least of material here that goes through what was being researched, what was being prepared, all that specific. So this section is the part that I find really inadequate. You're obviously going to list the person who provided the services, the amount of time spent providing the services, and then you will, they're not really showing the multiplier here, but you can see here that this particular attorney bills at $200 an hour. This paralegal bills at $74 an hour. I will tell you that paralegals in the Dallas-Fort Worth area, especially once they're well established in their career, are probably billing at $150 to $200 an hour. When you start out, you might be billing at $100, perhaps even a scooch less than that, but that's not really where the market is these days, and most attorneys are billing at least $200 an hour. So this is somewhat dated. Maybe this is reflecting more of a rural environment. But the takeaway is that this section needs to be longer, and the hourly rates need to be a little higher. Both attorneys and paralegals keep track of their billable hours. Those are usually the only people in a law firm who are generating income for the law firm. The secretary isn't billing her time. She's an overhead cost. She's not making a profit. She's not a profit center for the law firm. But the paralegals and attorneys are billing their time. There's more pressure on attorneys to bill time than there is on paralegals. For one thing, many attorneys are on the partnership track, and so therefore they have an incentive to impress the partners to show how industrious they are. For another thing, attorneys bill at a higher hourly rate, so every hour they spend working is more income generated. And for, I guess, a third point is that attorneys receive more income, and so therefore there's a greater expectation on them than there is on paralegals. But whether you are an attorney or a paralegal, you do need to keep track of your billable hours. Best practice is to do it throughout the day. Nobody likes keeping track of billable hours. In fact, when you ask people that go in-house or go to work for a corporation, why'd you do it? One of the very common reasons why they are interested in doing that is so they don't have to keep track of time. Even if you record your hours at the end of every day, you forget what you've done. It's easy to think, I couldn't have possibly spent 2 hours doing that. Surely that didn't take that long. And so you end up understating the amount of hours, and you look and go, wait a second, I was busy all day. How come I'm only billing 4 hours? In addition to keeping track of billable hours, usually legal professionals are also going to track non-billable hours, the continuing legal education that they provide, maybe client development projects they do, perhaps the staff meetings that they attended, or filing, or timekeeping, things along those lines. So they may record non-billable hours as well. It's not going to count nearly the same way as billable hours. Most attorneys and paralegals are going to have some kind of billable hour expectation, some kind of goal that they are expected or at least highly encouraged to meet. Non-billables are not going to work towards that, but at least they show the law firm, hey, I was industrious. I wasn't slacking off during that day. And again, these things are going to be kept track of during using some kind of timekeeping software. There is pressure, particularly on attorneys, to produce billable hours because, again, no matter how brilliant an attorney you are, if you're only billing 1,000 hours a year, which is shockingly low, and you're billing, we'll say, $300 an hour, well, the sole amount of money you are generating for your law firm is $300,000. Well, they've got to pay for a secretary, for a file clerk, for the office space, for legal malpractice insurance, lots and lots and lots of things. And so this it really isn't going to be able to justify much in the way of a salary for you when this is taken care of. The law firm is going to say, maybe you're brilliant, but you're not producing enough widgets for us. Another attorney who perhaps is billing 2,000, we'll say 700 hours, may not be less brilliant, but he's producing a heck of a lot more widgets, and so he might be more on partnership track than the 1,000-hour-a-year person. Typically, paralegals are not put on nearly as much pressure to bill time. Paralegals who are paid on an hourly basis, and we'll discuss the differences between being paid on an hourly basis and a salary basis in a subsequent lecture. But paralegals who are paid on an hourly basis oftentimes will want to work overtime because they're going to get time and a half for those hours. And so many times those individuals are finding that their billable hours are easily met because they're motivated to do so. If they're paid on a salary basis, obviously there's less of an incentive. But while there is still a concern about meeting your billable expectation, it's much less pressure on the paralegal than the attorney. So if you're considering being a paralegal or being an attorney and the idea of having a life out of work is really important to you, or not having billable pressure is really important to you, you may find being a paralegal a more comfortable life choice to consider. And let's consider the topic of double billing. This is covered in the textbook. There's an ABA, which of course an ABA stands for American Bar Association. The American Bar Association has a guideline which highly discourages double billing. The idea behind let me first of all explain what double billing is, and we can talk about why it's a bad thing in a second. Imagine that Sally comes in to the law firm on Monday, and she presents us with a question. Maybe the question is, what is the statutory period for a breach of contract claim in the state of Wyoming? And that's what her question is. So I'm just going to call it question A. So that's what Sally wants answered. And so she's going to pay me $200 an hour to do this research. And so Monday after she leaves, I immediately start doing the research. I find the answer and write a memo up, and it takes me 4 hours to do that. And I bill $200 an hour, so it's going to be a total of $800 to provide this information for Sally. And I finish it all up before the end of the day on Monday. Well, on Tuesday, Bob walks in, and lo and behold, he has exactly the same question. What a weird coincidence. He says, boy, I'm just dying to know what the statute of limitation is for a breach of contract claim in the state of Wyoming. And so guess what? I know the answer. And the law hasn't changed in the last 24 hours, so I can pretty much just pull out the document that I prepared for Sally, change the name from my memo to Dear Sally to Dear Bob, and so that'll take me about 10 minutes, and I can have him a work product, certainly spending no more than, we'll say, half an hour. So I can do this for him in, I'm billing at $200 an hour for $100. But I might think to myself, you know what? Why should Bob be the beneficiary of this? I mean, he could have come first. Or maybe Sally might never have come to me, and it really, the value of what I'm giving him is $800. That's what it took me to find the answer. So I ought to be billing Bob $800, and I ought to be billing Sally $800 because that's the value of what they're getting. If only one of them had come to see me, I certainly would have billed that one person $800. Well, the American Bar Association says, no. Each hour of each day has only 60 minutes, and you can only bill that time to one person. Now, you can bill 30 minutes to one person and 30 minutes to the other, or 57 minutes to one person and 3 minutes to the other, or whatever combination that you want. But no hour has more than 60 minutes. So if I'm billing 60 minutes of that hour to Sally, I can't bill any of that time to Bob. Now, in this situation, I haven't billed Sally yet for her research. So what I might do is I might add up these two numbers and say, well, the total legal fees for both of these projects is $900. So I'm going to charge Sally $450, and I'm going to charge Bob $450. They're both getting deals. But let's say that Bob actually came a month after Sally came in. Well, I will have already sent Sally a bill for the $800, so under those circumstances, I would need to bill Bob just $100. So Bob's gotten a break. He was in the right place at the right time. Good for him. He gets a good deal. I can't bill him as if I had never had somebody else ask me the exact same question a month earlier. Let me present probably a more realistic scenario of how this might work out. Imagine that I'm traveling on business. I'm here in Texas, and I'm going, my great state here. Pretty sad there, but you get the idea. So I'm here in Dallas, and I'm flying over here, we'll say, to Seattle. While I'm on the flight, or my fee arrangement with my client, the Seattle-based, is that I don't need to work on the plane. I can bill my travel time even though I'm reading a steamy novel, or I'm taking a nap, or I'm, filing my fingernails, or whatever I'm doing. I can bill that time even though I'm not working on my client's work. In fact, maybe My client may not even want me working on work while I'm on the plane because it's not sufficiently confidential. So I take the flight, and this trip from the time that I leave my home until I arrive at my hotel, we'll say that takes 6 hours. Probably take longer than that, but this is an estimate. And so I am fully prepared to bill my client 6 hours. Let's say my hourly rate is $200 an hour. So I am going to present a bill to my client for $1,200. Now let's say during part of that time, when I'm in the airport, I'm able to find a place where I can really be by myself. No one can see what I'm doing. And so I decide to do some work for my client. I would have had to do this work anyway, but I choose to do it while I'm traveling as opposed to when I arrive at the hotel. If I had done it after I arrived at my hotel, let's say I spent an hour doing that, then I could have changed it from 6 hours to 7 hours, and so I could have billed the client $1,400. But if I do it when I'm waiting at the airport, when I'm already billing $200 an hour, sitting there reading my steamy novel, if I decide to, instead of reading my steamy novel, that I'm going to work on my client's work, excuse me about so I can't bill the time twice. Like that hour can't be 60 minutes of travel and also be 60 minutes of work. So in that situation, if I'm waiting in the airport and I'm doing work for the client, I'm still only going to be able to bill the client $1,200. Let me present another scenario, though. Let's say I'm on the plane, and a client doesn't want me to do his work because he's concerned about confidentiality, but I have another client who really there's no chance that anyone on this plane would have any interest in the matter, and I'm being discreet and all this good stuff. So while I'm on the plane, I am doing some work for another client. My first client is already paying me $200 an hour to be on the plane because, after all, I have to be on the plane to get to his office. For this other client, I'm doing work for too. Well, guess what? I can't bill two different clients for that hour of time. I might decide to bill the Seattle client for 30 of those minutes and bill the client that I'm actually doing work for the other 30 minutes, or I might come up with some other arrangement, but there's only 60 minutes in that hour. So with this, I'm going to conclude this lecture. We have one more lecture and for Chapter 2, and then we'll be concluding with Chapter 2. Have a great evening. Thanks. Bye-bye.